Good evening and welcome to an introduction to guardianship alternatives. Today's session is presented by Erin Shahinfar, staff attorney at the New York Legal Assistance Group. INCLUDEnyc serves as the Early Childhood and School-Age Family and Community Engagement Centers, also known as FACE, for the NYSED Office of Special Education Partnership Project for all 5 boroughs. NYSED FACE centers are focused on providing technical assistance and professional development to support meaningful family involvement in the education system. As the Early Childhood and School Age FACE centers, we offer workshops for families and professionals, such as the one for tonight. And if you have any individual questions and want to speak to one of our staff, please call the Include helpline or fill out a help request form on our website. We will be sharing this information in the chat box. Please welcome Erin Shahinfar.
Hi, everybody. Julissa, thank you for the introduction, and INCLUDEnyc, thank you for the opportunity to present on this topic. All right. So as Julissa mentioned, I'm a staff attorney at New York Legal Assistance Group. We are a nonprofit that provides free civil legal services, financial counseling, and we do policy advocacy as well for people who are experiencing poverty. So just a quick overview of what we're going to talk about tonight. We are going to talk about 2 topics. Of course, guardianship alternatives, the subject of the presentation. But in order to do that, we're also going to touch a little bit on guardianship. And in terms of the alternatives that we're going to review, I've listed them here on this slide, but they can be broken into 2 categories. One category is alternatives to address personal needs, and then the other category is alternatives to address property. All right, so a good starting point for this topic is what happens when a person turns 18. So the law presumes capacity, and that means that an 18-year-old, even if they have a disability, has the ability to vote, marry, sign a contract, obtain medical treatment without parental consent, live independently, obtain and manage public benefits, hire a lawyer, and then they also have rights to privacy in certain kinds of records. So for example, education records, health records, those sorts of items. Now, are all 18-year-olds ready to take on these rights and responsibilities? Of course not. I would say that the vast majority of 18-year-olds, whether they have a disability or not, are not ready to take over absolutely all aspects of their life. At least, I'm speaking from my own personal experience. At 18, definitely needed the support of my family still. A lot of people who come to me, they'll, I have that quote at the bottom, they'll say, my child has a disability. I was told that I need to get guardianship in order to keep helping them once they turn 18. Is that true? So that is not necessarily true. A person who has a disability and turns 18, might still be able to make decisions for themselves. And there are different options so that they can continue receiving support if that's what they want and need. All right, so there are 2 pathways. Again, like I said, this presentation is broken into 2 parts. And typically, when people have a child with a disability, they find themselves at a crossroads. okay, do we go for, guardianship, or do we go for alternatives to guardianship? So as you can see from this illustration, the road to guardianship leads to court. The only way to create a guardianship is by going to court. Alternatives do not necessarily involve a court, and I have a sampling of different documents and supports that are part of this world of alternatives. And now, how do you choose which way to go? Kind of the central question when you might find yourself at this crossroads is at the very bottom of the screen. It says, is guardianship necessary to assist the person with the disability? So if alternatives are absolutely not going to work in your situation, then that's when you go the guardianship. That's when you may go the guardianship route. So what is guardianship? I have a picture of Britney Spears on this slide because she has kind of become the face of guardianship lately. So guardianship removes legal rights from one person and gives those rights to another person, the guardian. As I mentioned previously, guardianships can only be created by a court. They are considered a remedy of last resort. These are the most restrictive option for helping a person with a disability. Usually, in order to create a guardianship, the court has to make some finding of incapacity. And state laws govern guardianships, when and how they are used. So, of course, guardianship laws are going to vary state to state. So what is guardianship like in New York? There are two types of guardianship in New York, and each type applies under different circumstances and has its own procedures and terminology. So there's 17A guardianship, which is, the laws concerning that are in the Surrogates Court Procedure Act. And the person who is going to go under guardianship is called the ward. Then there's Article 81 guardianship, and the laws concerning that kind of guardianship, those are set out in the mental hygiene law. So Article 81 of the mental hygiene law. Article 81 guardianships are created by the Supreme Court, state Supreme Court. And in that case, the person who is going to go under guardianship or might go under guardianship, they are called the alleged incapacitated person, or the AIP for short. Also, just briefly, whether you're going for, if anybody going for 17A guardianship or Article 81 guardianship is going to have to specify what subtype of guardianship they want, whether they want to be guardian of the person, guardian of the property, or guardian of the person and property. Just briefly, guardian of the person is going to make personal decisions for a person with a disability who doesn't have capacity. So that's decisions about where they live, medical decisions, decisions about what kind of services they're going to receive. And guardian of the property, that is when a guardian has the power to manage a person with a disability's property and finances. Typically, guardian of the property is not going to be required unless the person with the disability has a very large or significant estate. They have significant assets. So like I said, there's two kinds of guardianship. Let's look at them side by side. And I'm gonna kind of, this is a whole, this topic, it's like a whole world in and of itself. So for our purposes, we're just kind of trying to get the lay of the land here. So 17A guardianship is what's called a plenary guardianship. It is total. meaning that if it's granted, the guardian has total powers over either the person or the property or both. That's not the same for Article 81. Article 81 can be more customized. So for example, the guardian can be given the power to, make medical decisions for the person with the disability, but that's the only thing, because the person with the disability is able to make the other decisions, or that's what the court has found. Article 17A can only be created if the person with the disability developed their disability before the age of 22, unless we're talking about a traumatic brain injury. And Article 81 does not have any age restrictions. Article 17A is very diagnosis driven. So in order to get this guardianship, 2 doctors have to certify, in their medical opinion, the person with the disability does not have capacity to make decisions for themselves and manage their own affairs. Article 81 is less focused on diagnosis, and it is more focused on functional level and abilities. Article 17A does not require, if somebody wants to be guardian under 17A, they don't have to take a class, and they don't have to file any reports once they're appointed guardian. And that's very different than Article 81, where if somebody wants to be an Article 81 guardian, they have to take a court-approved class, and then they have to file an annual report each year. Now, both of these guardianships have something in common, and that's at the very bottom of the screen. If whoever is petitioning for the guardianship, whoever wants to be the guardian, has to show the court that the guardianship is necessary, that nothing else is going to work. All right, so let's look briefly at the standard for 17A guardianship. This is what has to be proved. If you want this, this is what you have to show a court. You have to show the court to the satisfaction of the court. So, you have to show to the satisfaction of the court that the guardian is in the best interest of the person with the disability. And the elements involved in that are that the person with the disability is intellectually or developmentally disabled, condition existed before their 22nd birthday, they're not capable of managing themselves or their own affairs, their condition is permanent, and again, guardianship is necessary. Okay, Article 81 standard, similar. The standard is by clear and convincing evidence. If you want to be a guardian under Article 81, you have to show that, again, guardianship is necessary in order to manage to make personal decisions or to manage the property of the person with the disability. Plus, in addition to that, the person with the disability either has to consent to a guardian, or the person who wants to be guardian has to show that the person with the disability is likely to suffer harm without a guardian, that they're not able to provide for their personal needs and property management, and that they're not able to understand and appreciate the nature and consequences of this inability. Okay, so this is all begging the question, when is guardianship necessary? So I pulled out some pieces of case law and also for Article 81, some actual portions of the law. So under 17A, there's case law that says that a guardianship is going to be necessary, if there's a situation where a person with a disability cannot live safely in the community just with the support of family, friends, and professionals. Article 81 is more explicit in the law about what is required and when guardianship is necessary. So guardianship is necessary if the available resources are unable to meet the needs of the person with the disability. So what are available resources? These are basically guardianship alternatives, which I'll discuss in more depth throughout this presentation. And once again, you can see at the very bottom of the screen, there's a piece of case law that, again, guardians should be appointed as a last resort. Okay, so what does all that mean? What does the law mean? What does this case law mean? Basically, it means that guardianship is not going to be appropriate or necessary if less restrictive alternatives can meet the needs of the person with the disability. So try alternatives before seeking guardianship. It also means that guardianship is not going to be appropriate or necessary if the purpose of the guardianship is to prevent, a person with a disability from making bad choices in the future. That's not going to be appropriate. And then also guardianship is more likely to be necessary and appropriate if the person with a disability can't make their own decisions and they can't express their wishes. And now I'm not going to dive too deeply into this. The purpose of this slide is just to show that whether you're doing 17A guardianship or Article 81 guardianship, like this is a court process. So there are rules that have to be followed. Like this is litigation. So, certain people are going to have to receive notice that this court case is taking place, including the person with the disability. They are going to have to be served. The person with the disability, there also might be family members who are going to have to receive notice. And of course, anybody who gets notice of this court case, if they disagree, they can show up and express themselves. And similarly, the person with the disability, they can hire a lawyer and they can, defend themselves and, disagree with going under guardianship. And of course, there's a hearing. There's a hearing where the evidentiary, standards that we discussed will have to be proved, and a judge has to say, yes, I agree, this guardianship is necessary and appropriate. And similarly, Article 81, although I do want to point out for Article 81, you can actually, the person with the disability can request a jury trial. My understanding is that those are very, very rare, but it is a possibility. Okay, so concluding thoughts on guardianship. Once again, in a nutshell, guardianship removes legal rights from one person to another. And removes rights from one person and gives them to another. Guardianships are court created. They are generally permanent. So they last until the person with the disability dies or the guardianship is removed by the court. They are potentially time-consuming, expensive, and invasive. And again, you have to prove the necessity of guardianship, that no lesser restrictive alternatives are going to work to meet the needs of the person with the disability. So what are alternatives to guardianship? Generally, these do not remove decision-making rights from the person with the disability. They remain the decision maker. They are often not court created. They often do not require a lawyer. They are not permanent. They can be canceled or changed by the person with the disability. And they are less time consuming, less expensive than guardianship. So once again, revisiting, or I guess previewing the different alternatives that we're going to discuss. And again, these are broken into two sections. The first section is talking about alternatives that can meet the personal needs of the person with the disability. And then the second section is talking about alternatives that can help manage the property and finances of the person with a disability. So the first alternative we're going to discuss is supports and services. Supports and services are basically just less restrictive alternatives to guardianship that allow a person with a disability to meet their needs without a guardian. That might sound slightly circular. These can be formal and informal. So they could be provided by family members, friends, organizations. And at the bottom of this slide, I also have, the quotes from case law that we looked at earlier as to what supports and services are. And probably the best way to understand what supports and services even means is on the next slide. And it's just tons of examples. So for example, like supports and services that can help with property management. This could be something like a financial education class or a bill paying program or, supported employment, employment assistance, different like public benefits that help with bills. And then supports and services that can help a person with a disability meet their personal needs. These could be things like adult daycare or an assisted living facility, maybe an in-home attendant, a meal program. If somebody's not able to cook, they could have meals delivered. Housekeeping services, adaptive equipment, assistive technology, behavior support services, on and on and on. And then there are different organizations that can help connect people with disabilities to these different supports and services that might help them meet their needs. And I, again, just like list, that is one nice thing about being in New York. There's so many resources. So there's state agencies, city agencies, state protection and advocacy organizations like Disability Rights New York, disability resource centers, nonprofits, organizations and support groups that are focused on specific conditions. So like the Autistic Self-Advocacy Network or the Alzheimer's Association, on and on and on. And just briefly, supports and services go directly to the question of, is this guardianship necessary? If supports and services are helping a person with a disability meet their needs, then, the question is really like, what do we need the guardianship for? And I just pulled out in red some of the different things that will have to be shown to a judge. All right, moving on to the next guardianship alternative. These are called supported decision-making agreements, or SDMAs for short. So these are written plans in which a person with a disability chooses people they trust, called supporters, to help them understand their options, access information, and communicate their wishes. The person with the disability is the decision maker. And SDMAs can be useful for formalizing the supports and services that a person's going to use to help them meet their needs. And it can also formalize the names and roles of supporters and what kind of assistance the person with the disability wants from them. And it can also, often SDMAs are created at the same time as like information releases, which we'll discuss shortly. And so SDMAs can give supporters access to confidential information. So in some states, third parties are required by law to recognize SDMAs. For example, Rhode Island, Delaware, Texas, actually where I used to practice. And New York law does not currently require third parties to recognize SDMAs, but there is a lot of momentum for SDMAs. And my personal opinion is that eventually, hopefully soon, New York is going to codify these. So just some examples of the momentum. In 2016, CUNY, New York State Association of Community and Residential Agencies, Disability Rights New York, and the Arc of Westchester began a 5-year pilot program to promote supported decision-making. And that pilot's called Supported Decision-Making New York. Some of you all may have heard of it. And very recently, in December of 2021, the Office for People with Developmental Disabilities, OPWDD, announced that they would fund Supported Decision-Making New York for another 3 years. And the purpose of that funding is to help OPWDD develop policies related to supported decision-making agreements, and also develop the kind of supported decision-making services that they themselves will eventually offer. So very exciting. And like I said, when I used these in Texas, like big fan of these. Supported decision-making agreements are fantastic. All right, touching now on information releases. So like I said, sometimes SDMAs go hand in hand with an information release or several information releases. Information releases are documents which, in which a person gives someone they trust access to protected information. There are health, education, financial, and legal information releases that can be signed. The signor, so whoever signs the release, person with a disability, has to understand what records are being released and to whom. Information releases can be canceled at any time by the person who signed them. And here's just a sample. This is a HIPAA release. HIPAA is the acronym, so it's HIPAA. That's the law that protects medical information. So this is a HIPAA release. You know, somebody would write in their name and their address. They have to indicate what kind of records they want to release and to whom, and then they will have to sign and date. All right, on to another, onto another alternative. So Medicaid authorized representatives. A person with a disability can appoint an authorized representative to manage their Medicaid benefits for them. They have to, and there's a document that they have to sign, and they've got to submit it to Human Resources Administration or the New York State of Health. It's going to depend where they are getting their health insurance from, where they're getting their Medicaid from. Most people with disabilities, like if they're receiving SSI, they're getting Medicaid from the Human Resources Administration. So anyway, they have to fill out this particular form. They've got to understand what the form does and what its effect is. And then they can appoint, like I said, somebody to manage their Medicaid benefits for them. And if somebody is not able to sign this form, you know, an authorized representative, a power of attorney, guardianship, none of these things are necessary to apply for Medicaid on behalf of an incapacitated person. Federal law sets this out. All right, so another alternative related to healthcare, and many of you all have probably heard of this, a healthcare proxy. So a healthcare proxy is a legal document that anybody who's over 18 years old and not under guardianship can create. It allows a person called the principal to choose someone they trust, their agent, to make healthcare decisions for them when they are incapacitated. So this document only comes to life when the principal is unable to make decisions for themselves or communicate their wishes. It's important that the principal discusses their wishes with their agent, and specifically what we're thinking of here is end of life choices, because whoever is named as a healthcare proxy has the ability to make end of life decisions, so long as they know the principal's wishes. Okay, briefly, how to complete a healthcare proxy. This is a very simple document. Again, principal can appoint any competent adult whom they trust as their agent. You can only have one agent at a time. You cannot appoint an attending doctor as your agent, just because that would be a conflict of interest, or could potentially be a conflict of interest. You can't choose an employee of a hospital or nursing home if you're a patient or resident of that facility. And if the person signing this document has special instructions, they can include them in item 4 on this very simple 2-page document. Okay. The principal has to sign and date the healthcare proxy in front of 2 witnesses who are over the age of 18. If a principal cannot physically sign, they can actually direct someone else to sign for them in front of the witnesses. Whoever is named in the document as the agent cannot be a witness. And there are special rules about creating this document when somebody's in a hospital that's licensed by the Office for Mental Health. And no lawyer is required to prepare this document. So this is the document, very simple, 2 pages. A person, with capacity who understands what this document does can name someone they trust to make medical decisions for them when they're not able. They just write their name and sign in front of 2 witnesses over the age of 18 who are not the agent. Okay, so what happens if a person cannot sign a healthcare proxy? So if someone is not able to sign, and what we're talking about here is a situation where they don't understand the document, not able to express themselves, can't make this particular decision. So there is state law that sets out a default decision maker for a default medical decision maker for someone in a hospital or nursing home who can't make medical decisions themselves. And I've got the default order listed there. So, number 1 is if there is a court-appointed guardian, that person, if not spouse, if there's no spouse, then son or daughter, if they have that. If not son or daughter, then it's going to be a parent. All right. And if the healthcare surrogates under this particular state law are not available or they're in conflict, a medical facilities ethics committee may make recommendations to a treating physician. All right. So that was the personal needs side of alternatives. Now we're gonna pivot to looking at the financial and property side. So when people sign healthcare proxies, often they also sign a power of attorney. Healthcare proxy is for medical decisions. Power of attorney is for finances, and property only. So this is a document that authorizes a trusted person to manage financial and banking matters during the lifetime of the principal. The principal, so the person signing the document, doesn't give up their rights. They're still the decision maker, and they can choose someone they trust to carry out their wishes, and the agent can be over the age of 18. This document is durable, which means that it's effective even if the person who signed eventually loses capacity, so they stop being able to make their own decisions and express themselves. So the portion of the law that covers the power of attorney changed this past summer. There is a new statutory short form. To create this document requires a high level of capacity. But in a nutshell, it's just, you've got to, if a person with a disability is executing a power of attorney, they have to understand what the power of attorney does. They have to understand the powers that they are giving their agent. And beyond that, they have to understand like each and every provision in the document. Okay, so it's a high level of capacity to create this document. An agent owes a fiduciary duty to the principal, so they have to act according to the principal's instructions. An agent must avoid conflicts of interest. An agent must disclose the nature of their relationship. So, for example, if they're signing a check and they're an agent, they have to sign, James Smith, power of attorney or agent for Julia Smith. Power of attorney can be revoked at any time by a principal who is competent, and a power of attorney is not effective after death. This is a sample. This is just a snippet of the statutory short form, and this covers the different areas that someone can give an agent, power to act on their behalf in. So for example, like de-banking transactions, tax matters. And the principal would either initial next to each and every power that they want, or they can initial next to P and list out the different powers. One nice thing about a power of attorney is that modifications can be added to really tailor it to the needs of the person who's signing it. And I pulled out some modifications that are really useful. The first one, gives the agent the power to manage public benefits for the person who signed the document. The next one is the power, so the principal can give their agent the power to represent their interests in housing and lease issues. And then the last one is the power, an agent can have the power to fund trusts, to put the assets of the principal into a trust. And that could be a pool trust or a supplemental needs trust. Okay, just briefly. So a power of attorney can be, and like I said, that last modification that could be added in related to putting property into trusts. Medicaid has income and asset limits, as I'm sure many of you know. And in 2022, those income limits are $934 for a single person, $1,367 for a couple. So a power of attorney can be useful for Medicaid planning. And why would you want to do Medicaid planning? Because Medicaid is a provider of free long-term care. And long-term care can be provided in the community or in like a nursing home or institution. Okay. Now, most of the young people with disabilities who I work with like I said, power of attorney can be useful for some things, but many of the people who I work with don't have a lot of assets. In fact, mostly what I see most often is that their primary asset is their Social Security check, like their SSI payments. So a Social Security representative payee, this allows a person to manage Social Security benefits for someone else who is mentally or physically incapable of managing their own benefits. This is a process, if somebody wants a Social Security representative payee appointed, they're going to have to contact the Social Security Administration, and the SSA does their own kind of like investigation and determines whether a representative payee is going to be appropriate. So if somebody is appointed a representative payee, they must open a separate bank account for the benefits that they are managing. And they need to keep records of how the payments are spent. And a person with capacity can designate someone, they can designate up to 3 people to serve as representative payee in advance of need. So what does that mean? That means that somebody with capacity can say, okay, in the event that I lose capacity, I'm not able to manage my benefits on myself, I want these people to be my representative payee. And I included the link there, and I think the slides are going to be shared after this, so you can always read more on the Social Security website. Okay, another alternative related to property and finances is certain kinds of property ownership can actually solve some issues. For example, somebody with a disability can create a convenience bank account. This is where an account holder adds someone else's name for convenience only. So that gives the person who they've added the ability to write checks from the account, to handle bill paying, to handle transfers, things like that. Or another option is a joint bank account. Once again, similar to convenience account in terms of the abilities of the person who's added, but a joint bank account can create a right of survivorship if one of the account holders dies. So if there's a joint account and one of the people on that account passes away, their share of the account automatically goes to the surviving person on that account. Okay, another kind of account, many of you all may have heard of these ABLE accounts. So an ABLE account allows certain New York residents disabled before the age of 26 to save money in a tax-free savings account and use the funds for expenses related to their disability. You can save up to $15,000 annually in these kinds of accounts, and the account can basically maxes out at $100,000. So any ABLE account less than $100,000 is excluded from SSI and Medicaid resource limits. And ABLE account holders can choose how to invest their money and decide when they want to make withdrawals. And tax-free withdrawals include, for education expenses, health and wellness expenses, housing expenses, on and on. And once again, I included the link on this slide. If you're interested in these, you should definitely read more on them. They're similar to 529, like college savings accounts. Okay, and then the next alternative is trusts. Once again, this is like a whole world in and of itself. And, this presentation is we're going to kind of like fly over this large area of law. But so a trust is an agreement that involves one or more grantors. So that's the person who gives the property that's going to go into the trust, a trustee who manages the trust property, and then a beneficiary. That's who is eventually going to end up with the property that's in a trust. So there are supplemental needs trusts. These are special trusts that enable individuals with disabilities to maintain their eligibility for government benefits like Medicaid and SSI. Supplemental needs trusts have to be created before age 65. And again, a supplemental needs trust can address having excess monthly income or excess resources for Medicaid. There are also pooled trusts, and those don't. So a pool trust doesn't usually have an age limit but there are pooled supplemental needs trust, in which case, there is the age 65 limit. All trusts require authorization in order to be created. So for example, if you become a Social Security representative payee, and you want to put a portion of the income into, or a portion of that benefit into trust to help somebody qualify for Medicaid, you wouldn't be able to do that. Like I said, trusts are going to require special authorization in order to be able to create those. So that's either a power of attorney or guardianship, or like a one-off court order. And if you are interested in the world of trusts, you should definitely consult with an attorney. They're going to, you'll need a lawyer in order to create these. Okay, so final thoughts. A person with a disability does not necessarily need a guardian. Guardianship, again, removes legal rights from one person and gives them to another. A guardianship is only created by a court. And in order to obtain guardianship, the petitioner, so the person who wants to be guardian or wants somebody to go under guardianship, is going to need to show that guardianship is the least restrictive option available. Alternatives are not going to work. And once again, try alternatives first. Okay, so this is my contact information. You can feel free to reach out to me if you have any questions. Although I think I'm going to answer some questions now, so we may be able to address them. But again, here's my information if you have any other questions. All right. And yeah, thank you guys so much for your attention.
Hi, Erin. Thank you for all that information. Yes, there are a couple of questions in the Q&A and a few in the chat. So let me know, how would you like to proceed?
Let's see. I'm going to stop sharing my screen, and if you want to read them, I can kind of answer them from there, or I can read them myself, whatever makes sense.
Okay.
Yeah, maybe if you would read them, since you've been seeing them come in, and now I see there's sometimes some other stuff in there.
Okay. The first one I have here in the Q&A says, would the parent of a child with autism need to formally obtain guardianship once the child turned 18?
So again, that's going to depend on whether guardianship is the only way that you can help the child with autism or the person with autism. I have worked with many people. I mean, the thing is that autism is such a spectrum, and it's so specific to the person who has that diagnosis. I have done all kinds of guardianship alternatives for young people with autism. You know, I have also met with different people with autism who, you know, like we weren't able to do guardianship alternatives. They weren't, the person with autism, like, wasn't able to understand the alternatives, wasn't able to express who they want to help them and how. And so I guess my answer is that it's really going to be specific to, you know, your child. And yeah, I mean, but the point is that you should absolutely try alternatives first.
Thank you. And the second question is, if I am appointed guardianship, do I still need to apply for the healthcare proxy?
So, okay. So a healthcare proxy is signed by the person with the disability. And again, the healthcare proxy can only be signed if the person with the disability understands what the document is and what power they're giving to somebody else. If that is the case, if somebody with a disability understands those things, then guardianship is probably not going to be appropriate. Because again, guardianship is going to be more appropriate when somebody with a disability can't make their own decisions and can't express themselves. So if somebody understands a healthcare proxy, is able to sign it, is able to express who they want to help them with medical decisions, then they may not need guardianship.
Thank you. Another question, how expensive or time consuming is the process of getting guardianship or guardianship itself?
So it's gonna depend. So the short answer is, like, for 17A guardianship, the filing fee is $20. But there are all kinds of issues that can arise that would potentially affect cost. So for example, if the person with the disability wants a lawyer, or if, you know, if you need to serve notice on somebody and you can't find them. So there's different things that can affect cost. It's hard to, there's not exactly like a set and clear cost across the board every single time.
Will the PowerPoint be shared with the participants? The slides?
Yeah, I think so. I'm happy to, after this, I can send the PowerPoint to Julissa, and you guys can feel free to distribute it.
Okay. I have another one. Is it safe to say that you can add 3 guardians?
So I'm not sure I understand the question. Is it safe to say you can add 3 guardians? So if you are going to court because the person with the disability cannot express themselves or make their own decisions, typically courts will appoint one person. They'll appoint 1 guardian. They might appoint 2 if it's like mom and dad, but usually not. Usually the court is appointing 1. And that's partly just because it makes it easier on everybody if there's 1 decision maker. It can get confusing if there's multiple decision makers, people making different decisions and potentially disagreeing.
Thank you. Another question. If the individual with the disability has an intellectual disability and signs a HIPAA or other release, in your experience, do doctors or medical professionals question whether the individual has the capacity to understand what the individual signed?
So I have helped people with intellectual disabilities sign HIPAAs, and I have not had an issue. Again, like it's going to be very specific to the person with the disability. Do they understand the document? Are they able to express who they want to get their records and talk to their doctors? But no, I actually have not had a situation where a doctor has looked at a HIPAA release that I've helped a person with an intellectual disability prepare and said, I don't think you have capacity to sign this. I don't think this is valid.
Is there an age restriction for the SUNY Hunter College Disability Program, and post the, if you can share the Hunter College SUNY info?
Yeah, I'm happy to. So this is for the supported decision-making pilot program. You know, I'm not aware of an age restriction, but I'm happy and I'm happy to share the information. So I guess short answer, I don't think there's an age restriction. And yes, I can absolutely share their information. And again, I'm a big fan of supported decision-making agreements. They can do a lot of great stuff.
At what age do I start the process for guardianship?
So I think that, again, it's going to depend. I think that as somebody gets closer to 18, that's going to be when it makes more sense. Yeah, assuming that a person does need guardianship, like they're not able to express themselves, not able to make their own decisions, I think the very earliest that you can apply for guardianship is when they're still 17. But I personally, in my own practice, don't like to do that, just because I think it is hard to know what the need is for guardianship yet. You know, if they haven't turned 18, it can be hard to tell, like, what exactly do we need this guardianship to do? What are we not able to do for this person with a disability right now?
Thank you. And I believe we have a couple more minutes, if that's okay with you. I have another question saying my son turned 18, but SSI counted parents' income and not giving him enough SSI. SSI said it will count parents' income and parents' self-business income too.
Yes. So what I would say about that is you can feel free to, so I don't typically handle SSI issues like that, but if you have, if you think that, you know, there's been an error, or if you want to get particular advice about that, you can, you know, reach out to me at the information that I included, you know, in this presentation, and I'll make sure that you get to the right person at New York Legal Assistance Group. Like I said, I don't typically handle those particular issues.
One says, my child is in and out of state residential school. My child is now 17 years old. When should I begin the process? And I believe it kind of ties in with the other question of when to start the process, but I'm not sure.
Yeah, I mean, once again, I think my answer is the same, is that it's going to really depend on the child and what their abilities are. And you should definitely try alternatives first. Try to do alternatives, try to do the different items that we discussed. And if your child is not understanding them, you know, then you, like I said, you will, in order to get guardianship, you have to tell the court, like, look, nothing else is going to work but guardianship. So try alternatives first. And yes, like closer to 18 is when those things are going to make sense, because only an adult can sign the different alternatives that we discussed.
Okay, thank you so much, Erin. And I believe that is all the time that we have for questions right now.
Thank you guys so much for having me. It's really been a pleasure, and feel free to reach out to me if you'd like me to evaluate your child for any of the alternatives we discussed.
Thank you, everyone, and have a nice evening.